Well, hello everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, and we turn our attention today to Sarah Boone. You'll recall Sarah Boone is in trouble for stuffing her boyfriend into a suitcase during a game of hide and seek and leaving there to die. And he did die, and it's very sad. You'll also recall that Sarah Boone has been through 9 lawyers, 8 of whom were court appointed. She started off with her own private lawyer way back in the beginning, and then through a series of 8 different court appointments, eight court appointed. She managed to get most of them actually all of them to quit. Some of them were for conflicts of interest, but 3 or 4 of them threw in the towel at least, saying we can't work with this woman. And the judge's like, okay, I give up. So we had a status hearing today, where we're just reviewing where things are in the prep to trial. So just have a status hearing. So we're going to watch this 18 minutes worth of clip and see what it says. Should be fun. All right.
Case number 24,
Mr. Cacciatore.
Dave Cacciatore on behalf of the state.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, good morning. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
We also have a representative from Prison Break Investigation. Sir, if you could come forward, please.
Exciting.
If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator for Prison Break.
Okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boone is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to coordinate the appropriate processes with the jail. In conversations with the jail, a laptop has been secured and will be issued to you after USB drives are provided with all the discovery. Upon the jail's receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone.
So since she now represents herself, she's entitled, of course, to all the discovery. So the judge is just like saying how it's going to happen practically. So that's basically what happened. It's a very long order for how this is going to happen. So between 8 a.m. and 4 p.m., so for 8 hours a day, you can have access to this laptop. The charging cable will not be put into housing because, there's problems with that, obviously, because someone might hurt themselves with the cable or, either hurt themselves or hurt someone else with the cable. So, and it will be, kept in inventory by the jail. So it will be kept by them as inventory, but they will not obviously look at it otherwise because obviously it is confidential information. So that's very long story short. She gets access to the discovery. It will be provided on a computer. She can access the computer 8 hours a day and go from there. Exciting, fun.
The discovery was provided at the court previously and is in the 2 bankers boxes that are in front of the court to your left, Mr. Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through Prison Break Investigations, shall copy all of the discovery onto as many USB jump drives as necessary. The Judicial Administration Commission for the state of Florida shall be responsible for the fees and costs due to Prison Break Investigations for copying all of the discovery onto as many USB jump drives as necessary. You will appear,
I'm sure one will be fine.
For a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse with the discovery and all USB jump drives containing the discovery. A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, Prison Break Investigation shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation. Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
supposed to be out of state from Tuesday until Fridays next week, which I believe would encompass August 1st for my son's wedding.
Okay, well, congratulations. When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay, will you be able to complete that task by that time?
Yes, sir, I'll do my best.
Okay, sir, we will see you on give me a second, I want to make sure I get the date right. Monday, August 5 at 8:45.
Yes, sir.
Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused.
I bet you are. So this guy is a private investigator. I understand that. My understanding is this guy has been working with Sarah Boone and or her lawyers on some sort of ongoing basis. So he's not just some random guy. He has been he was hired by somebody at some point, and his services are continuing to be employed. He might have been employed by the court, I'm not sure, as a PI for the defense team. He might have been employed by one of the defense teams, but whatever. But in any event, he has access to a lot of this information. And so, please, basically scan in all the documents from the banker's box, get your scanner, put it onto a jump drive and give it back to us on the 5th. Great. No problem. So forth. So easy, right? Great. All right. Sarah Boone has questions. Let's hear her questions. This should be fun.
Was a notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state.
So there you go. That solves that problem, right? So the PI was given to her as part of the defense. So there you go. So he's a PI paid for by the defense or paid for by the state for the defense. Fine. Great. No problem.
You're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him. So he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges.
Fine.
Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work. And I understand that your case is important, and I want to move as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space, you have almost no privacy, you have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
Fair enough.
Process that I would.
Right? So yeah, sometimes we have to make it up as we go along. Fair enough, right? So she's being held in a jail. She's being held in a dorm style jail apparently, and doesn't really have a private space for herself. So she doesn't have space for her materials. So how do we get her the materials now that she is the attorney? How do we get her the materials so that she can have it and review it? And how do we make that work? So the judge had some conversations with the jail in terms of logistics. This is what the jail says they can make work. The judge says, okay, fine. This is what we're going to do. Everyone's happy. Why didn't you get notification about this hearing? There's literally no way for me to notify you because you are the attorney. There's no way for me to notify you. I was like, okay, all right, fine, I guess. I'm not sure why they can't send a letter or something, but it is what it is. So fine.
Was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed
that's not going to be
anything
practical.
that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail.
This is
I
one of the
understand that's your
disadvantages.
preference,
See,
but-
this is one of the disadvantages when you're being held in jail and you're going to represent yourself, because now we have to make things work with the jail. And that can obviously provide all kinds of problems practically. And so we will figure out something that will work. It may not necessarily be your ideal. It may be, maybe it's paper and you prefer electronic, or maybe it's electronic and you prefer paper, whatever. But it's we're going to have to figure out how to make this work in a way that makes the jail happy and also protects your rights. So no, you can't have it in writing. No, you can't have a hard copy. This is what happens when you represent yourself from jail, people. It's a bad scene.
I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right. Okay, so I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copy.
No, you can't. No, you can't. You're allowed to have it between 800 hours and 1600 hours. So no, you can't have it at 2 o'clock in the morning because, again, you're in jail. That would be the continuing problem here for most of this. The continuing answer for most of this is you are in jail. And there's going to be some restrictions on this because you are in jail. And you didn't have to be in jail because, well, you didn't have to do the bad thing. But you did the bad thing, and, we are where we are. So, yeah. Try harder.
So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
Will I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared, and obviously I do not know what I'm doing, and obviously I'm still
that much is
my
true.
discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just miss a week, a month.
The dates are what the dates are.
So I also sent you, I believe, 5.
I mean, she does have a fair point, to be honest. It's like, it's like, well, that doesn't give you, I don't have that time to prepare. But, again, this happens a little bit when you F around and find out. So, there's an appellate issue in there somewhere. Didn't have sufficient time, although, to be fair, she's had 4 years. So, no, probably not.
Motions, have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
Okay. 5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can?
Mr. Lane, who contacted you in order for you to be here, please?
The JA contacted me.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right, which
It
is
makes things
malformed.
exceptionally more difficult.
Oh,
as I
malformed.
explained.
Malformed. They're malformed. Malformed isn't what you're looking for. You need a different. You need a different word choice. Erroneous would be probably better as an argument word, but okay, yeah.
To you in communicating with the court and communicating with the state attorney's office.
Isn't that what a certificate of service is for anything that's filed by anybody
Fair.
in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as and perform as?
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
I'm honestly not sure why that necessarily is, incidentally. On a technical level, I assume there's a technical reason the judicial assistant can't do that. But I can't think of a legal reason the judicial assistant can't do that. Because the judicial assistant is working for the court and contacts the parties and would contact the attorneys. So if an attorney was going to do a status hearing or have a hearing, it would not be, an attorney might be contacted a number of different ways regarding that. But being contacted by the clerk, judicial assistant, would not necessarily be unheard of, right? That would be one way that you'd be notified. So I'm not sure why. Obviously, the judge doesn't do it himself because that would be potentially ex parte because he's having a conversation, but not sure why the judicial assistant doesn't make the call. Maybe it's a special Florida rule. Maybe there's some sort of practical reason within the confines of the jail that the judicial assistant isn't doing it. Maybe it's because it's pro se the judicial assistant doesn't do it. I don't know. But the fact that they're not doing it strikes me slightly odd, but I'll take a note of it.
How is it the news knows before I do?
You keep asking the same question, and the answer is going to be the same. I cannot answer that question for you because I do not know.
Okay, but you do know it's harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am, if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to, and it took time for a process to be created by the Orange County Jail. As they had advised me, they do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised is the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know.
Yeah, it took some time. As the judge just said, it took time because a process had to be created. They had to invent one. They had to invent a process. You know, so it took a hot minute. We've been pursuing it diligently. This is now the solution we've come up with. You're now being notified of the solution we came up with. Yeah.
What to say, and because I supposedly have no way to contact you other than a letter, and the same for you. I don't know how the news crews got here before I did, but I don't know going forward how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me. Is that what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them, and if we have to set a hearing, you'll be properly noticed for it.
Probably by surprise.
Certificate of service.
You'll be properly noticed for it, yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
Ooh,
You're
noted.
certainly entitled to that opinion.
Is this constitutional? In principle, yes. In execution, debatable. But yeah, you can forfeit your right to an attorney. The court quoted the relevant case law. You could obviously challenge the basis of the court doing that, whether it was sufficient or whether or not the court gave sufficient notice. But yeah, you could. But yeah, in principle, yeah, it's constitutional. It's like if you F around hard enough, yeah, the court system's going to move on.
Allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I will be happy to do that. It is the policy of the Orange County Jail to have a letter represented from an attorney to allow me to access you. That's the reason for the past previous couple of attorneys I've not had the ability to come out and access you, but that's changed. And I will be happy to continue to move forward with any investigative actions that could be for your defense, as long as I can get that access.
So you need a letter from me?
Or the judge, or the jail, somebody that will allow me access to you. Yes, ma'am.
And I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything.
But you all are the ones who contacted him.
But I can't tell the jail, let this person come talk to you. If they have a policy where you need to provide the letter, then you need to provide the letter.
So until you have that letter, you and I will not be able to speak with one another?
I will contact the jail myself and find out if there's an exemption from pro se, or maybe they can speak to you directly to circumvent the actual letter itself.
Thank you.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Atheist Ant for $50. Thank you for the generous super chat. Is the judge just being overly nice? The judge is demonstrating patience. Yes, but that isn't unheard of with pro se's. Judges will tend to give a little additional latitude as a general proposition to pro se's because they're on their own, and we'll try to give them a little bit more grace as a general proposition. But the judge is being kind, and she's being respectful, and he's being respectful back. And yeah, so yeah, but thank you very much for the super chat. I appreciate the $50. It's very thoughtful.
Yes.
I will be on.
Please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right. Thank you all very much. Mr. Cacciatore, anything further, sir?
Nothing from the state.
All right. Thank you very much.
Well, I guess that's it.
Thank you, Your Honor.
Thank you, sir. Have a great day. Oh, wait. Before you leave, that is all going to be yours. Yes, I would, sir, so that you can begin the digitization process. All right. I'll see you on the 5th. Perfect. Thank you, sir. Yes. I'm just...
She is a piece of work. Yeah, I don't think there is. Yeah, the laptop doesn't pre-exist, right? They're creating one, and she doesn't get access to additional methods beyond what a typical, well, except as would be required. So it sounds like they're rolling their own adventure here, which, again, makes logical sense in the context of this case. There's a lot of information, so we've had to create something that will satisfy due process. So on the basis that no other inmate has access to email, and to the extent they do, they have to use some sort of like console-based thing, then she isn't entitled to more than any other person, right? She's only entitled to as much as is required to give her due process. So since she's representing herself now, we have to give her access to the discovery, which is the information, but not necessarily the email, because, well, that's not what a typical inmate has. Because why would she need email? Her email would only be to facilitate communication with outside parties, and the methods for the communications with outside parties is controlled by the jail. So the judge is not going to order email or even restricted email unless it would be necessary to facilitate the interaction. So that's basically what's going on. So it's just basically jail protocol, long story short. And so it's like, okay, look, we have some concerns, right? We don't want the charging cord in with the inmates, because it could be used to hang somebody, it could be used as a weapon, it's a strangling tool, it's a garrote basically, right? So it's like, okay, we don't want it to be in there. It's like, okay, so we'll have it so it's not in there. Okay, we're going to give their access to the laptop, but it's not going to have any external communication. Okay, fair enough, because it's just being used for reviewing of discovery, that kind of thing. So yeah, it makes logical sense and seems fair enough as far as it goes. All the rest of it. So yeah. No, she's not yet been convicted. No, she's been held without bail pending her trial. She is charged with top count murder, and so she's being held pending trial. I don't know whether or not she was offered bail or not. Probably not. And if it was probably too big a number. You think the judges want the clerk to contact her in case she's abusive? Could be. I don't know. Yeah, there could be a lot of reasons for it. I don't know the answer to that question. So, I don't know. They should not be allowed to guarantee she's convicted. They aren't guaranteeing it. They aren't guaranteeing it. She has a right to a fair trial. She has every other right at her disposal. She only forfeited her right to an attorney, or at least a court-appointed one at that. So she has every other right at her disposal. Anything else? A pro se defendant, should we give the ability to represent themselves while jail like this or not? A person always has the right to represent themselves. But if they're in jail, that being in jail comes with limitations for the safety of the prison and inmates and contraband reasons. So we now have to deal with those factors as we're trying to figure out how to deal with things. So being in jail comes with limitations. So, there's that. So we're going to try to make them work within the scope of the limitations that are available. So it sounds like they came up with a pretty reasonable approach. You can have access to the computer 8 hours a day. It'll be charged every day. All the data will be on there for your review. We're giving you access, as soon as practical, so forth and so on. So seems like a reasonable solution to the problem. Ted Bundy had access to a library. I'm not clear that she doesn't have access to a library. I'm not clear that the judge does. I'm not clear that she does or does not have access. She might not. I don't know whether or not the prison has a library, but sure. And also Ted Bundy's a different person in a different state at a different time in a different jail with different procedures. So what is true of Ted Bundy is not necessarily true of anyone else, because each jail is going to be different. Each jurisdiction is going to be different. The state law is going to be different, and so forth and so on. Jail protocol should not be able to remove access to prepare for trial or to have access to discovery and then prepare for trial. Well, what's the alternative? What's the alternative? You just say that, but like, what is the solution to this problem? It's like, okay, if you accept the premise, that she is a flight risk or a danger to others, and therefore bail should not be granted at all, or should be at a high amount that she can't afford, so she needs to be in prison or jail. If you accept that premise, and you accept the premise that she forfeited her right to an attorney through her actions, then, okay, given those two premises, what other solution do you propose other than what the jail is doing? Seems like a reasonable course of action. Yeah. They're giving her as much as they can give her within the confines of the situation. So they're trying to accommodate her. And it sounds like a solution that accommodates her, even if she'd prefer other things. But then again, she's in jail, so she doesn't get everything she wants. Does she get to go to a special room? Unclear. I don't think so. Not that I understood. Also, that's fair. During Ted Bundy's time, laptops probably weren't really practical. Fair. How does she have access to discovery if she's not allowed to see the boxes? Because the boxes are being scanned into a USB drive that will be given to her on the computer. That's what the court just said. The banker boxes are to be scanned by the private investigator, presumably onto a PDF, put onto a USB stick, I guess, then uploaded to the computer, and she's going to be given the computer. That's how she gets it. Yeah. If another inmate steals or breaks her laptop, well, then we'll have to deal with that contingency at that time, right? Then presumably we'll have to provide her a different laptop or some other solution, but we'll deal with that when we cross it. It sounds like a reasonable solution to me. Sounds like a reasonable solution to me. The jail's treating her different from other pro se defendants? How? And to the extent they are, they're giving her more, not less. So how, in a way that prejudices her, are they treating her differently? Are they treating her differently because she's pro se, or are they treating her differently because of some other reason? right? So if you're saying that they're treating her differently, your first question would be why? Because that would go to the nature of the bias or prejudice, right? So if I discriminate against someone, the reason why I discriminate against them goes a long way as to whether it's lawful or not, right? If I discriminated against the customer, is it because of their race or is it because of their attitude, right? For example, that's just an exemplar. So the reason why becomes really important. The fact, so they, assuming they're discriminating against her, why? Is it because she's pro se or is it because of some other reason? If it's some other reason, then that's neither here nor there. It's because of the other reason. If they're giving her more than a typical pro se defendant, then she doesn't have any basis to complain. If they're giving her more, someone else might have a basis to complain, but she wouldn't because she has no standing because she's getting more. So I don't understand your question or your concern. I don't really understand what you're trying to say. It's unconstitutional to take away access to discovery just because she's in jail. No, she's being given access to discovery. She's being given access to discovery. It's going to be placed on a computer that will be delivered that she'll have access to for 8 hours a day. So what are you talking about? No. Yeah, if the situation changes, the court can deal with it as it changes. Exactly so. Right? We're gonna try something, and if that doesn't work, we'll try something else. Yeah, that makes sense. I suppose it's constitutional only give someone a few weeks to prepare for trial, but you see, you've made a mistake there. She hasn't had a few weeks. She's had a couple years through with her various attorneys. And so she's had plenty of time. She may have squandered that by squandering her attorneys, but that's by her action, not by anyone else's. She's had plenty of time. She's had plenty of time. So, yeah. So, no problem there. How likely is it she'll be receiving an appeal based on this pro se decision? Unlikely, but possible. Unlikely, but possible. The easiest basis to appeal would be just that the court wasn't clear enough in its notice. Because the court basically said that if you F around, things may occur. They didn't really make the clear threat. So that'd be the clearest basis to appeal on that particular issue. But, you know, yeah. She's also complained about how long it's taking. That's true too. Yeah, exactly. Do I think she'll be found guilty? Yes. Very extremely likely. Extremely likely. To the extent that she has any defenses, she would not be really well equipped to put them on. But that would be true for any pro se, which is one, again, why you would discourage someone from representing themselves. So, yeah. Doesn't she need to file a motion if she wants more time? She does need to file a motion for continuance. Yeah. She needs to file a motion for more time. That's why the judge said, well, it's scheduled as it's scheduled. It's like, if you want more time, you need to file a motion for a continuance. Not that it'll be granted, but it preserves the issue in the record. It cannot becomes unconstitutional because of actions of the defendant. Yeah, you can forfeit your rights. You can always forfeit your rights. That's always true. You can forfeit your rights. So it's it's constitutional. You just effed around so hard that you forfeited your rights. You can forfeit your rights by your waiver, right? You can choose to do it. You can choose to forfeit your rights, choose to represent yourself. And you can also do it through your actions. You know, you can do it through your behavior. It's like, yeah, there are punishments, there are penalties. And it wasn't the first thing the court tried. It wasn't their first thing out of the gate. So they're like, okay, you forfeited it by your behavior, forfeit it through your actions. Yeah, that makes sense. Yeah, it makes sense. That's one of the reasons, like, the police can arrest you in the first place. For example, why can the police arrest you? I mean, generally speaking, why can the police arrest you? If I'm walking down the street, can the police arrest me? No, generally speaking, they can't. right? But if I, suddenly go and behave in an unlawful way, yeah, I forfeited my rights, right? Or more to the point, the Fourth Amendment trigger is now pulled because it's now, they have probable cause, depending on how you want to frame it. But yeah, this is fine. And the case law is legioned, as the court cited. So that is correct. If you disagree with the statement, if you disagree with the law, then I don't know what to tell you, because that's just the statement of the law. That's just the correct statement of the law. And I'm a legal educator. I'm just here to explain to you the law as it currently exists. If you don't like that, I don't know what to tell you. If that's the right answer. You, of course, can solve this problem substantially by not effing around so hard that you find out. And then you don't have to worry about it. So, there's that. Do you think the burden of placing this gang on discovery to be a reason for appeal? No. It's a reasonable solution. The PI previously existed. The PI has existed beforehand. He is already inside the privilege envelope because he was appointed as a private investigator to the defense long ago, so he exists within the privilege envelope. So he's a very reasonable person to do it because he can look at the material without it breaking privilege. Because he's a paralegal, kind of, if you like. He's within the privilege envelope. It'd be the same way as me as it would be the same way of me as an attorney hiring a PI or hiring a paralegal, right? They get my privilege because they're working for me on behalf of the case. So they're within the privilege envelope. So that's probably the most logical person to do it. So yeah, that makes a lot of sense. Would a lawyer have been able to ask for more notice before being summoned? Sure, a lawyer could ask for more. The lawyer could say that they're conflicted, or could say that certain dates are not available. Of course, that's not so true for her because she's very available. We know where she is. She doesn't have any conflicts. We know where she is. But sure, a lawyer could ask for a different time because they have something else to do. Yeah. Yeah, the PI gets privilege by being assigned to the defense. He was working for the defense attorneys and now he's working for her, I guess. So he's within the privilege envelope. So no problem. You want to represent you, but you aren't dumb, especially lack of time. Yeah, I received communication. I received communication from a party closely connected to the case who indicated that if I were serious about representing Sarah Boone, they would recommend me and believe that Sarah Boone would welcome me as their attorney. I am somewhat disinclined to take on the representation at this time because I just don't have the time. This is the problem. The best I could possibly hope for would be able to understand the evidence that already exists. If I put my every waking minute into it for 2 months, would be understand the case as it currently exists. I wouldn't have any time for any independent discovery or any independent investigation or the ability. I wouldn't have time to hire, a psychiatrist or other experts or anything like that. So the best I would be able to do within the time frame that be available would be understand the information that currently exists. I'd be very unlikely to be able to put on a defense case of any kind, even if I could piggyback off of other defense cases that have been built up by prior counsel. I wouldn't be able to put it together and actually execute it within time. So yeah, no. Could I move for continuance? The court strongly indicated the answer to that question is no in their order, where they said that a continuance won't be ordered except for extraordinary cause, and hiring a new attorney ain't it. So yeah, I mean, I could file for continuance, but the court's already told me they're going to deny me. Of course, the very fact they're going to deny me could now be the basis for a future appeal, but yeah. So I don't know that I should say yes. But I received an email. I received an email from a party close to the case, who suggested that they could facilitate my representation if I were interested, and they also suggested that a third party entity would be willing to pay for my actual expenses, such as lodging and stuff. Well, that happened, and that was interesting. But I think I'm going to probably have to pass. So yeah. Would I want to represent her in the time frame available? I don't think I could really do a very good job. This is the problem, right? As an attorney, rule 1.1, right? Like the very first rule, like, is basically to give competent advice or competent counsel, is literally rule 1. What does it mean to give competent legal services? What does that mean? Well, it means, among other things, that you need to understand what the hell is going on, and you need to be able to understand what to do. That doesn't necessarily require you to have any particular prior experience, but it does require you to get up to speed on it. And so within time frame, I don't know that I could fully give competent legal representation within the bounds of ethics, because all I could really hope to do maybe is find ways to possibly attack the state's case. I don't really think I would have time to put on a case of my own, or put on a defense of my own, or hire experts of my own, or otherwise develop a defensive strategy other than trying to pick holes at the prosecution. So within the time frame remaining, I'm not sure that I could bring myself up to the competency the rules of ethics would demand. So I think I'm going to have to take a pass. Given what little information is available at this time, my primary strategy going in would be trying to attack mens rea. I'd be trying to look for ways to attack the intent element behind the crime, because the video kind of speaks for itself on the actions elements. So I think I'd probably be trying to attack mens rea to show some sort of diminished or inhibited capacity of some kind. Would be probably my first thought going in. Yeah, so my first thought would be trying to attack mental state. That'd be my first idea. Also, I could try to attack duty in some way and say that she had no obligation to get him out of the suitcase. And so I could attack duty and see if I could do that. Do standard rules of ethics apply in extraordinary circumstances? Of course they do. They always apply to an attorney at every time, because a client is entitled to competent legal counsel. They're entitled to a competent attorney. So, yeah. Would it be unjust or unconstitutional not to let her have notes? She, I think, can have notes. She could probably store them on the computer, I would think. And if not, she could take handwritten notes, I would imagine. I don't know. Plus, I seriously doubt the judge would admit me, to be quite honest, at this time. I have basically no trial experience really to speak of. I have my work historically was transactional. It was pushing paper, which, is which is law, to be sure. You're still pushing paper, but it's not trial work. So, I don't really have the background. Plus, I'm not a lawyer in Florida. So I'd have to get someone to sponsor me. And who would sponsor me? It's like, So it sounds like a bad idea all around. I think I'll just sit back and, have fried chicken instead. Come down to Florida, you may find your future wife. I'm not sure whether to accept that as a blessing or a curse. Are you trying to bless me by saying that? Or are you trying to curse me by saying that? Is that like the may you live in interesting times? Is that what you're doing right now? Come to Florida, you may find your future wife. It was also civil, not criminal. Yeah, that's true. Yeah, so and it's also federal. It's also patent law, which is pretty divorced from whatever this is. So yeah. Can Judge Cannon sponsor in Florida? Probably technically. Yeah. May you live in interesting times. Yeah. Can the court appoint a public defender? They're going to say they've already said no. They appointed 3. Well, technically they appointed 8. They appointed 8 public defenders. So the court's not appointing any more public defenders. They're done. So yeah. I don't know if Peter would appoint me. Or I don't know if Peter would sponsor me, to be honest. And I wouldn't blame him for saying no. I wouldn't blame anyone for saying no. You know, it's a fairly, you know, some different lawyers have different perceptions about it, but some attorneys feel like they're on the hook for it to some degree when they sponsor, and also like I don't really have the requisite experience. So even if I don't know Peter particularly well. I don't know if we've ever been on stream together. I don't know if we've ever had a conversation together. So we don't know each other. So I don't think he's going to go out on a limb for me. Plus, he might just say no for my own sanity. You know, he might say no to protect me from myself. Can I explain mens rea? Sure, it's the mental state requirement. So in any crime, you have mens rea and actus reus. It's the 2 things you need: the mental state and the act. It's what you need. You need the guilty mind is the other way of putting mens rea, the guilty mind. So depending on what you're being charged with is different variants of that. So we talk about intent, knowing, reckless, negligence, strict liability sometimes as different mental states. So, you know, I kill somebody, you know, okay, there's an act that's been performed because I've just told you, like, I have performed an act, someone has died. Am I guilty of anything? Well, I don't know yet because I haven't given you enough information, right? So, and if I am guilty, what am I guilty of? I still haven't given you enough information, because what differentiates like first, second, third degree murder, voluntary, involuntary manslaughter, criminally negligent homicide, and so forth and so on, right? Murder comes in like 8 different flavors. And what separates these flavors of murder is principally the mental state requirement as the guilty mind. Also, I might not be guilty of anything, depending on the circumstances. I might only be civilly liable, for example, if it was just a negligence. If through pure negligence, I cause someone's death, I'm not criminally liable, but I would be civilly liable, you know? An example of which would be, for example, let's suppose I'm just driving my car, not in a particularly reckless way. And let's suppose I get into your standard run-of-the-mill automobile accident, all right? And someone dies. Well, I may not be guilty of anything because, you know, they died from, you know, a freak situation, you know, as opposed to being caused by me. I mean, you can come up with other examples, but you know, that mental state requirement is a principal thing. So if I were looking to defend Sarah Boone, the first thought I would be like attacking the mental state requirement, like depending on exactly what I'm trying to do, right? So trying to lessen her culpability by lessening her mental state requirement would be the principal way I think I would go about trying to attack it. So yeah, and it would be an ethical issue for Peter too. Yeah, and he might see every reason to ethically decline. And I wouldn't hold it against him if he declined. Not that I'm going to ask him in the first place, because I'm not going to put him in that position. Not for at least the reasons I don't know him that well. But yeah, I mean, sponsoring another attorney can put you on the hook personally, depending on the situation. And also, like, even if it doesn't, it's like you want to have enough confidence in the person you're sponsoring. So, you know, there's that. Can she make all the same motions she could without a lawyer? Yes. Peter is great. I have no problem with Peter. Peter's fine. Peter is great. He's wonderful. I have no problem with Peter. In fact, if anything, I'd like to know him better on a personal level. Not necessarily because of this, but just in general. He seems like a cool guy. I just have never really had a conversation with him. No particular reason. Just we've never really crossed paths. He doesn't seem to have people on his show. It's been a long time since I've reached out to him. Maybe I should reach out to him again. Maybe we could have a conversation about this. I don't know. It could be fun. You lifted 33,000 pounds in the legs? Awesome. I kind of had a half workout today. It wasn't my best. I went to the gym today and I only did about 5,000 pounds today. My back started hurting and I turned it in early. But hey, we showed up to the gym and we tried to do something, and something is better than nothing. It's 5,000 pounds I otherwise wouldn't have done. So you're not exactly breaking records or anything, but hey, it's a start. I appreciate any lawyer who stands on their own ethical code. I like to think I stand on my own ethical code too. I like to think of myself as a very ethical person. And I hope every attorney considers themselves an ethical person and tries as best as they can to lead an ethical life. I have no problem with him. He seems like a nice guy. Seems like someone who's thoughtful, cordial. I have no problem with Peter. Peter's cool. He's also wildly successful on YouTube, so he's got that going for him. He's also arguably more handsome than me, and I have to hold that against him. But, we can't all be blessed with good looks. So if I have to find a reason to dislike Peter, it'll be because he's arguably better looking than me. Lame. How do you count pounds at the gym? Total pounds lifted. So when I say 5,000 pounds or 10,000 pounds, it is the combined weight of all the weight I lifted. So for example, if I lift 35 pounds 10 times, that's 350 pounds. And then if I do that 3 sets of that, that's what? 1,050 pounds. So that's when I'm calculating that. That's total volume. So if I say, I lifted 5,000, 10,000, 20,000, 50,000 pounds a day, that's total volume. That's all the weight of all the exercises added together. And in this particular case, the app does it for me. I use Fitbod. It does great. I like Fitbod. Yeah. Peter is lawyer, Yeah. Lawyer, Very successful YouTuber. He seems to really crush it on live streams in particular. He's definitely got a je ne sais quoi I don't have. I'm not sure what it is, but because if I did, I would just take it and then I would have the je ne sais quoi too. But what can you do? That's an app. There are many apps for lifting weights. There are countless apps for lifting weights. Yes. The one I use in particular is called Fitbod. I like it. It's an AI app that keeps track of your workouts and suggests workouts for you. And suggests them based on fatigued muscles and stuff. And it keeps track of them. There are many fitness apps, and that one I use in particular, and I like it. It's my personal favorite. Strong is another classic one. There's one called Volt that's really good for if you have access to a full gym and you like, traditional like non-machine based exercises and you have access to a full gym. Volt's very good. BodBot, don't really like as much. There's one called JE Fit. It's okay. Yeah, but I like Fitbod. It's the one I like the best. You think he looks like Johnny Depp? Yeah. I sometimes got Phil Seymour Hoffman and I haven't gotten Johnny Depp yet, so I don't know about that. Mine is a gym workout. It's 100% free. Yeah. Fair enough. Some of those apps are free, by the way. Some of them are free. Fitbot, of course, is also free, I think, just for tracking. If you want the AI recommendation, it's like $99 a year. But yeah, I mean, the gym I use is just the one at my apartment complex right now. So the gym itself is not costing me anything. And the app is like $100 a year. So it's great. I mean, a training session from a trainer will cost $50. So it's like, well, it's the cost of 2 training sessions. So it's like, it's a pretty good deal. Cachette, Peter mispronounces your name every time. Nice. All right. Well, I'm going to go ahead and sign off for now. Yeah, I probably will not take this case for my own sanity. Plus, it would be ethically questionable at best, I think, to take this case. So I probably will have to pass on it at this time. So, yeah, I'm going to go ahead and sign off. I've really enjoyed you spending some time with me. I hope you enjoyed spending some time with me. And we'll be on later. If you have suggestions of stories you want me to cover, just a reminder, you can join my Discord. It has a place for you to come and provide story suggestions. This story was suggested by one of our Discord members, and you can be a Discord member that suggests things too. And then I'll be happy to cover them, and it'll be fun, and we'll have exciting. It'll be good times had by all, and all the rest of it. So, you know, all that good stuff. I've been on Civil Law. Until later, my friends, I hope also, what day of the week is it, by the way? Thursday? Oh, we're doing Thunderdome. We're doing Thunderdome tonight. So yeah, before I sign off. So what are we going to say? Are we going to say 7:30? Are we going to say an hour and a half? Let's say an hour and a half. Let's say an hour and a half. Hour 20 minutes. We're doing Thunderdome because it's Thursday. All right. We're doing Thunderdome tonight. So we have some stories from last week if we don't have new stories, but we're doing Thunderdome tonight. So an hour, 20 minutes from now, we're doing Thunderdome. It's a legal roundup show, and we can have more conversation then. It'll be fun. It'll be exciting. You know you love it. I love it. You love it. It's great for everyone. I've been on Civil Law. Till later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.